Okay, so we're ready on the record on Rashaun Jones, the defendant, his attorneys, and the state are all present. I'll let you put your names on the record since there's extra and less of the attorneys.
Marlene and Valerie's gonna on behalf of Mr. Jones.
Okay, so we have one extra defense attorney who's not filed a notice of appearance yet?
Or speaking on the record.
Okay. All right. Yes, please. And then Ms. Peabody's not coming or,
No, she's not gonna be present.
okay. All right, and then state, I see we have one. Ms. Diamond, you want to just put your name on the record?
Sorry, yes, Your Honor. Assistant State Attorney Christina Diamond and Kristen Redmond.
Okay, do we have to wait for Ms. Rodriguez or can we start?
She just stepped in back.
Okay,
We should be able to.
all right.
And so is defense counsel, I'm sorry, I heard they have a new counsel for that?
No, they're not going to have Ms. Peabody present today.
Okay, I thought there was.
No.
Right. Oh,
All right. Okay, thank you. And so defense, would you like to begin?
Yes, Judge. So, we're here today. We have the motion to dismiss, but before we address the motion to dismiss, we also have the motions regarding the Detective Segovia Instagram account Balance of Justice. And I know Your Honor wanted more verification regarding the fact that actually is tied to Detective Segovia. And so I have present Adam Mosher, who is the founder of Cybertech, who has been and can give the court additional information and answer any questions the court has.
All right, so before we begin with his testimony, hold on, I keep getting people unmuting. All right. Right, defense, have you subpoenaed any of the documents from the metadata for that email or that Instagram?
No, but I haven't been able to because I need to get one of the emotions of.
All right, I don't know what happened. All of a sudden, there's like a static here.
Although I do know that the state had communicated, I believe it was up from last year and potentially the year before that, that they had, themselves subpoenaed those records. So I don't know if they've gotten any returns on that.
Okay, state?
You know.
All right, so if the state is going to be requesting the metadata and providing it, then is that motion now moot?
No, Judge. We want to be able to obtain it ourselves. We don't want to have to rely on the state to actually obtain the records and then actually provide the records.
Okay, and we had reserved ruling on that because,
Your Honor wanted additional information regarding the attribution.
Good morning, Judge. Kristen Rodriguez on behalf of the state. I believe you're at the last setting, Ms. Diamond did point out that what was provided by defense was stated at the top, it was like an AI transcript and couldn't be relied on. And so then there was a question about whether or not this individual was even going to testify.
well, wouldn't it be moot if we had the metadata?
no, sorry, Your Honor. I thought the person was coming to testify as to what information he was provided by the defense, if he
Right.
knew if there was a law enforcement officer, and what he was specifically asked and under what pretenses? Was it under a cyber stalking? Was it under something like that? I don't know if he's present and listening.
He is.
But that was, I thought, the purpose of this. It's separate and apart from that.
So I don't know why that would be something we would set this for and not,
Well, because it would be a violation of the Florida statutes
what would be about it?
for somebody to get the information and disclose it publicly if it's a law enforcement officer, for example, as in this case, as well as if there was a crime that was being committed, what crime was alleged to have been committed. So that's the way that you would have to, by statute, get the information. It's not just like looking up on Sunbiz and seeing who owns a corporation. There are certain statutes that apply, which we thought the individual who had provided this document had a little disclaimer indicating that it was to be relied upon only for certain purposes. And if he was aware that it was law enforcement that he was disclosing, and if there was a crime that was being committed that he was informed of, or whether he was just disclosing it without having that information, so we would know if there was a law violated, which would make it inadmissible.
So we're having this inquiry to determine if his search was legitimate and not if Detective Segovia, if what he found was actually attributed to the detective.
Well, he's already said that you can't rely on what he's found.
Well, he has not said that, Judge.
I don't have it-
I'm here to speak to.
Okay, does somebody, I have a million motions.
Before we move forward, because I want to make sure that,
Yeah.
you know, we don't overlook this. Is there a statute that the state or the court can point us to that you're referring to?
Yes, it's the same one that protects my information from being disclosed.
And then the second. thing
Which
that I-
also, which would also be the same information that would be protecting Segovia, not only as a law enforcement officer, but the spouse of another law enforcement officer. So both of those people have protected information of which was disclosed. So first, we have to go into the validity of the search. And second of all, whether or not it's able to be relied upon. I don't have the actual report here in front of me. If you have it, you can read the disclaimer, which we read on the record before.
Judge, can we please have Mr. Mosher explain the disclaimer if we're going to speak about the disclaimer?
Well, what I'm gonna do right now is just put him in a waiting room because we're having that discussion now, and I think it would be inappropriate to allow him here for our portion and then cross-examine him or speak to him about it. So, Mr. Mosher, I'm gonna put you in a waiting room if that's okay, and then we'll bring you back in a moment.
Understand.
Okay, so let's see. All right, so he's back in the waiting room.
The statute is 914.15 law enforcement officers non-disclosure of personal information.
914.15.
Yep, and it's any law enforcement officer of the state or any political subdivision thereof who provides information related to a criminal investigation or in proceedings preliminary to a criminal case may refuse unless otherwise ordered by the court to disclose his or her residence, address, phone, telephone number, or any personal information concerning the officer's family. Any law enforcement officer who testifies as a witness in a criminal case may refuse to disclose personal information concerning his or her family unless it is determined by the court that such evidence is relevant to the case.
So it would go to the reason why we had everything redacted, because it's something that could not be disclosed.
No,
But-
Judge, what the statute says is that the law enforcement officer has the ability to not disclose that should they not want to disclose that.
No, that's not what it says. And read it further and you can read the application. Right, there's also another statute which allows them to have it blocked, which all officers and judges have. So that information is blocked from being disclosed as well.
Well, it wasn't blocked.
It was. It doesn't mean that it's not existent. It's all blocked.
So
It's the.
This is why I gave some time so that you can all look at it. And I said on the record the last time that I didn't know if this individual was going to want to come and testify without representation, being that he could be testifying potentially as to something that would expose him to liability. So I don't know if you've all discussed that with him since we were last here, but I did put it on the record the last time. And he has that specific disclaimer, which if I found his report, has to do with not relying on it. I don't know if you need to take a moment, but we've had a couple of weeks to prepare for it. And I guess when you prepared him for his testimony, you would have discussed that with him.
I don't see in another subsection for 914.20.
There's another statute.
There's a couple other statutes.
Right.
I would also, that's the first one that came up. I would also cite to point, Florida statute 119.07, which is a public record exemption that categorizes the home addresses of personal information of active or former law enforcement officers and their families exempt from public records disclosures. I'm just pulling all of them, 'cause there's a couple.
There's a
Okay,
bunch.
well, so far, none of them apply.
Florida statute.
Have you looked at them?
43.17.
Yes,
Wait. You looked at 119.07?
that's a public record statute.
Yeah.
Okay.
Right.
I can make a public
Did you-
records request.
Okay. I have them
Okay.
misdemeanor.
All right, go ahead.
843.17, publishing the name and address of law enforcement officer, any person who shall maliciously or with the intent to obstruct the due execution of law, or with the intent to intimidate, hinder, or interrupt any law enforcement officer in the legal performance of his or her duties, publish or disseminate the residence, address, or telephone number of any law enforcement officer while designated the officer as such without authorization of the agency which employs the officer, shall be guilty of a misdemeanor in the first degree. That's another
And
one.
that also
I can
doesn't
keep
apply.
pulling.
Okay,
this down.
Not, so far, none of this applies. First of all, this was not publicly, I redacted all of the information, so as far as that goes,
well, wait. I received it unredacted.
right, in
The
terms of.
state received it unredacted. We're gonna determine if anyone in your law firm received it unredacted, and if the court originally received the clerk's office unredacted. The problem is, this is akin to disclosing, say, information where there's a child victim and things of that nature where the statutes do apply. And I know that you're saying that none of these statutes apply. I'm saying I'd like to have a hearing as to each of these and see if any of these apply. And I think you should afford your witness the opportunity to review it with counsel in the event that he has violated any of these statutes before you put him on the stand and subject him to criminal liability, which is what we discussed in the past.
I still do not see how any of these statutes apply, so I'm
Okay.
happy to have a conversation with him. Yes.
You,
Judge?
okay, I understand you don't see it. I think it would be
It's
prudent.
not explain how
Hang
any
on.
of these apply.
Hang on. I think it would be prudent, I know you don't think any of them apply, to discuss it with him and let his legal counsel make that determination if he chooses. Only because I would have to advise him that he might be subjecting himself to criminal liability by answering these questions. Now, I understand you represent Mr. Rashaun Jones, and your concern is Mr. Jones's best interest. But this witness also has potential legal liability, which I don't know the answer to, nor do I do the analysis. Even if I did know whether he was subjecting himself, I think there is a good legitimate reason why we disclose this in advance so that you could discuss it with him. Because if I disclose it and I tell him, then we're wasting today. So I'm hoping that that was discussed.
Again, I don't go, yes, is there another statute?
I would just point out that the other question that the state may ask is, in that particular AI document, there was a note that said that the particular account was violating sort of Meta's policies, almost as if the way that they obtain the information was through a law enforcement portal, which talks about threat, harass, and I think stop. And that if, I mean, I'll let you read the act, but if it could be a violation of the Federal Source Communications Act, which is 18 USC sections 2701 through 2712. And that is part of the law enforcement portal when subpoenas are sent under that particular subsection. So, you know, at least for us, as law enforcement agencies, when there's a stalking case or harassment case, we have to sort of assert that there is, I would say, a minimum PC.
Okay, I don't believe.
So I would just, that would be another statute that I would think may come into play, obviously not here, but certainly any questions that are answered may be implicated in somewhere else, so.
All right, can we have a moment, Judge?
Sure.
The public records. That's the home. Everything becomes redacted.
I found the. How are you?
That's what I wanted. It's still, I'm good with that.
All right, we have everyone back in the courtroom. Go ahead.
Yes, Judge, so. Our understanding is that while the court said, you know, we should check with him to let him know. That the court was concerned that there could be some statute being violated or some Florida law being violated. Our understanding was that this was on for him to testify regarding. The attribution.
It is.
And I still have not heard any statute that would apply. However, given that the state is throwing out different statutes. We spoke with Mr. Mosher about whether he would like to speak with an attorney and in an abundance of caution, because we don't exactly know what the state is going to allege here. He's gonna do that before he gives any testimony.
So I thought that was part of one of the reasons why we hadn't ruled on that particular motion. I'll read onto the record again, the limitation of the report that he filed. And I think it's very important because as we discussed, we need authentication. And this document specifically excludes itself from being authentic.
Well, Judge, I'm not sure. Is the court addressing the actual substance of whether this attribution is legitimate, or is the court addressing the legality of the search?
Okay, it would have to be both things, because one, if a search is illegal, then I can't rely upon it, right? Just like if someone goes into a house without a search warrant, then I wouldn't be making a determination as to whether this is authentic or not. We wouldn't get to that. So
That's what
it's the same.
I'm asking why the court would be reading that on, why the court is addressing that if we're not even.
Because
Ask.
it's what you provided to me. So here's my point. I started by saying, wouldn't any of this be irrelevant if we were getting the metadata, which is able to be authenticated? So why are we jumping through these hoops for no reason? If you're going to be able to rely on the metadata, then we don't need to go through this. We don't need to expose this person to criminal liability potentially, and we don't need to authenticate it.
Grant the motion that I filed.
We have to get to that point. See, there's a whole bunch of issues with this that I pointed out because we were going to get into potentially the authentication today. If he was able to surpass the questions that we initially asked him, then we were going to move into the next point, which was the authentication. And here it specifically says, which is why we talked about it the last time. This report is intended to support investigations, risk assessments, and due diligence activities. It is not intended to serve as definitive evidence. Users are responsible for independently verifying findings before making any decisions. I would be inept if I ignored that and did not verify the findings in here before making a decision. So, I mean, he's telling me in his report. And then we have the issue
To verify this.
through his testimony is what you proffered. So I'm willing to listen to his testimony. I just cautioned you, though, that I'm afraid that there could be some things that would subject him to liability, because it also says that this was done, it says reason, threat, harassment, stalking, cyber profile, and threat rating. So if he was asked to do this investigation because of a threat or harassment or stalking, we would be informed of that. And I don't know that we're going to be able to establish this. So I have a lot of issues that I need to cover if you're going to admit this. And I just wanted to put you on notice that we might not need to go through all of that if you went a different route. I'm happy to hear it. I said today.
What's the other route that the defense can go down if the court is not willing to grant the application for an order to Meta without this information?
I haven't heard argument on it, so I haven't denied it. It seems interesting to me, though, because there's been a couple of reports from the media that match some things that were disclosed in one of your motions that the court hasn't ruled on. It says in the motion and it said in the media that the court has denied certain motions that I haven't heard yet. So I don't know how that would have happened. But that being said, I haven't heard that motion. And the only other one that I have that has to do with this information, I reserved ruling on, which is the metadata. I said I would reserve ruling because you all wanted to proffer some things and admit this document, I guess, as basis for the metadata. So I'm going to do whatever you're asking me to do. I just needed to caution you all because it's something that is clear from some of the statutes. And because he is saying that this is not authenticated, he's saying, don't rely upon it, verify it independently. I'm gonna have to do that. So I don't know if you want to put him on or not. It's up to you all how you want to proceed. I just wanted to put that on the record to preserve any issues later for a case if a case arises. In addition, whomever he disclosed to that is not one authority or one person might also be liable or criminally charged. It's like when I am asked to do, like I said, the child motions, I authorize one person at the Christie House to review it. I authorize and we designate a person. So if we knew this was going on, maybe we would have designated just you to receive the information or proceeded differently. I don't know that that has happened. I'm only saying it as a caution so you all know how to proceed, looking beyond the trees at the forest. So you let me know. He's here. I'm ready to do these motions.
Well,
What do you want me to
given
do?
that he is in an abundance of caution going to speak with his attorney. And I mean, this is he's done this work in Florida before.
Against law enforcement officers that were not committing crimes?
Well, Judge,
And that would be a very important
that would
answer.
be a question that we can ask him once he
Do you-
is cleared to testify.
Okay. We heard this, what day was that we were last on? Before this? About 2 weeks ago, was it?
Yes.
Okay, about 2 weeks ago. I don't know why he hasn't done that.
I have not found any statute that applies.
Okay,
But
you
given
said
the
that,
state is throwing out different statutes.
have you reviewed those statutes? You said all of the ones that they just threw out.
Yes,
Okay, and you believe that none of them apply?
yes.
All right, I disagree.
Okay, well, that's.
And I
what-
think that's why he
for
has-
this Caution, we let him know that maybe it's a good idea for him to actually confer with his attorneys, and we don't know what the state may do.
But I said that 2 weeks ago.
Right, except that there were no statutes that the defense believes.
Well, I don't usually provide all the statutes and the work that you all need to do. I explained it to you all. And I wished he would have done that because now we're sort of stuck in a position where we can't go through these motions. All right, so he's not going to testify today, so we can't discuss the preservation either?
Well, if he's not gonna testify, Judge, no, we can't.
Okay, so I'll put that aside.
At the preservation, the court already granted.
No, I know, I'm saying what was preserved, we can't discuss it either at this point. Let's see. Cross-examination of Detective Segovia, well, we can't really discuss that.
Anything that has to do with Detective Segovia and the balance of
Yeah.
his Instagram account, we are obviously not going to be able.
I'm
to-
just reading them because there's a whole bunch of them. There's the motion in limine regarding cross-examination of the Detective Segovia that we can't hear today. Supplemental defense motion in limine regarding cross-examination, so that's a supplemental one. Defendant's application for order compelling production of stored electronic records for metadata, so we can't do that one. What motion can we do today?
Motions to dismiss.
What about, I have already ruled on the George French Jones.
Yes, and we're going to be asking for reconsideration of that after his deposition testimonies.
Okay, but he's already been deposed, right?
Yes, that's what I'm saying. Given that that was addressed before he was deposed. We're going to be asking for reconsideration on that.
Did you file a motion?
No, but it's the same exact thing that I was requesting before that was denied.
Well, it can't be the same exact thing because I think you would be citing to parts of the deposition so that I could reconsider.
Well, the deposit, so in the motion to dismiss, the
Uh-huh.
deposit, did your honor have a chance to review the motion, both motions to dismiss?
Yes.
Or rather the renewal one and the supplement.
So here's the other issue. I received, again, it's amazing to me that we were so ready that I keep receiving more motions and more supplements to the first motions that were filed that we were ready to go to trial without hearing. On June 9th, I received this packet, a supplemental motion to dismiss. I couldn't even count how many pages. Now you're asking me to reevaluate another motion, but not providing any substantive new information to reevaluate it with. So I'm gonna not reevaluate my denial,
I would ask that your honor reevaluate it after we address the motion to.
and I'm telling you I won't. until you file a motion requesting it, citing to all of your arguments as to why I should.
One of the requests in the motion to dismiss is that if the court is not going to dismiss this case, one of the alternatives is that we actually get this information that we had previously compelled.
I
And
understand.
the motion sets forth the testimony that is the basis for that request.
I understand. I'm telling you, you're asking for two different things. I'll consider the motion to dismiss. And if you would like me to reconsider a specific motion, you need to break it down as to why you want me to reconsider it and all of your arguments so that the state and the court can be prepared to address those issues in regard to a motion for the discovery on George French.
Okay, not a problem. And I just want to make the record clear that the supplement was filed. The court was aware that the supplement was going to be filed and invited us to file a supplement following the deposition, because the reason we didn't address the motion to dismiss was because the deposition was set following the day that the hearing.
I don't recall the motion to dismiss not being set. I remember that we were talking about George French Jones's information, and we would address it more in detail if in fact something happened at the deposition that we needed to be aware of. But the fact that I'm aware that there is a motion that's going to be filed doesn't mean that I'm aware that it's going to be filed. Actually, it just so happens that this was not sent to me or to our division email. It was only sent to my judicial assistant, who happened to be out of town until this morning. So the reality is I had no way of knowing that it had been filed. I only
Did Your
know.
Honor have a chance to review the
Yes, I
document?
only know because the clerk told me something had been filed. And so I got information from the clerk as to what was filed. And that was at the end of last week, just so that you're aware. So normally I would ask again to file motions to the 007 division email during working hours within enough time for me to review whatever it is that you're filing. It's an instruction I've given a number of times. It's an instruction that's been violated a number of times. And I'm putting it on the record one last time in the hopes that we don't have to go into any kinds of contempt hearing, because it's not the first, second, or third time that it's violated. So I'm making it as clear as I can that these documents need to be filed like everybody else files things in this division to the 007 email, as well as during work hours. That would be Monday through Friday from 8 to 5. Just so that everyone is aware, this one didn't qualify, but luckily the clerks have been eyeballing it for me and letting me know. All right, so I did review it. So now you want to hear the motion to dismiss?
Yes, sir.
All right, I'll hear argument. I guess we'll have to set another day for all of the other motions. I won't be here until July. Okay. Go ahead.
So the motion to dismiss, the renewed motion to dismiss, and the supplement to the renewed motion to dismiss are based primarily on 3 grounds. One of the grounds we're not going to be able to address today because of the Detective Segovia Instagram account situation that is not going to be verified today. The other 2
I think we can
grounds
still address it.
is the court going to accept as true that the account ties to Detective Segovia?
I don't have to accept it as true. I think we can still address it, arguing that in the event that it has any weight to it, whether there's prejudice to this case going forward now, whether it was a violation of any rule that I gave, whether any of the jurors viewed it, or if it had any prejudicial effect, we can go through all of those steps, not even knowing if for sure that is Detective Segovia's Instagram.
Okay, so that's one of the grounds. The biggest ground, the major issue involves George French Jones, the jailhouse snitch that the state relisted on May 1st after excluding him as a witness on July 9th of 2025, not calling him as a witness during the first trial, and then relisting him just a few weeks before the second trial was set. George Jones, and so there are multiple issues with George Jones, but to start at the beginning, George Jones was an informant who was expecting benefits and was promised benefits from Michael Von Zandt. Michael Von Zandt is the prosecutor who was assigned to this case, who filed charges in this case, who stated very clearly just a year before charges were filed that there was insufficient evidence to sustain a viable and ethical prosecution, and then a year later filed charges on exactly the same evidence. A few months after Mr. Jones was arrested and incarcerated, Mr. Von Zandt turned over discovery involving listing a new witness, George Jones, and providing a statement that Mr. Jones gave. What the state did not disclose, however, is the contacts that they had with George Jones. They didn't disclose the contacts. They didn't disclose the promises that were made to George Jones. It didn't disclose the other cases in which George Jones has offered information and cooperated with the state. During deposition, George Jones testified that Mr. Von Zandt absolutely promised him. He said he was 100% sure that Mr. Von Zandt promised him that he would make calls to the United States Attorney's Office in connection with his federal case. He believed that he was going to get a sentence reduction for his cooperation, or that at a minimum, Mr. Von Zandt was going to make efforts to make that happen. He was so upset because he felt that these promises were not kept, that he threatened to taint the state's case, which is why they struck him on the July 9th hearing date. So there have been multiple due process violations throughout the pendency of this case. And George Jones is an example of that, but it's also on a whole other level, given the giglio violations involved, given the fact that we are entitled to cross-examine him on all of this material. And to date, we still have not received any of the material that he alluded to, minus maybe a few emails during that deposition. We also have not received the email that Ms. Diamond alluded to at the last setting, where she said that Mr. Von Zandt had emailed her saying that he had never met with George Jones. Or rather, I'm not sure Ms. Diamond can correct what the email said, but I think it was something to the effect of maybe even had never spoken to George Jones. George Jones made it very clear that that was not the case. So he testified to having met with Mr. Von Zandt in person at the state attorney's office. And during that meeting, he provided information on this case and on other cases. None of this has been disclosed to the defense. Only through deposition of George Jones did we learn any of this. George Jones also testified that he had sent Ms. Diamond between, at first he said 90, and then he said, oh, no, it wasn't 90, it was 20 to 30 emails. We have not received those emails.
Okay, so I'm not going to stop you completely. I just want to address some of the issues because there's a whole bunch of things that have come up. So I don't want to lose track. Let me go back. One question that I need an answer to before I can continue going forward. State, did you strike Mr. Jones based solely on the fact that he threatened to tank your case or something of that nature?
No, we were on the eve of trial. The state had, myself and Mr. Rodriguez had not met with him in person, and due to all the issues that were arising, the voluminous, the motions the defense had filed, and we had a lot of emails and materials to go through in order to comply, to make sure there was no legal material. So at that point in time, having not met with him with trial coming up a week later, we decided to strike him.
I remember you've said that on the record before.
Yes.
I think 2 or 3 times, even back before the trial.
And said at that time, we had addressed it that very day because we had officers there to pick him up. And we just wanted to let the court know, or see if the court was going to instruct the state to continue having him brought so he could be deposed, because he was deposed at that time, you know, and the trial did get reset, it might have been something that we continued with.
So right now,
It was addressed that day because the defense had filed a motion to compel the information regarding George Jones and a motion to depose.
sure, within a couple of weeks of the trial, which is why the state is saying that they chose to strike him at that time because they didn't have an opportunity to get all of that information. Now that the case is reset, there is much more ample time and we were able to bring him for the deposition. I was instructed, not on this case specifically, but on all of our cases, to not bring down witnesses that are in custody, to hold them here for trials that don't have trial certain dates. So we've been sending back a whole bunch of people that have been brought over for depositions and for testimony because the jails here don't want to house them indefinitely. They want them to go back to state prison because the funding is different. So that's not out of the ordinary, but at the time, the state chose not to call him for the reasons that they've proffered. And I don't have any reason to believe that they're being misrepresenting to the court. In addition, it just reiterates the fact that they were not misrepresenting to the court because they've now listed him. So if he was going to tank their case then, he'll tank it now as well, and we'll see what happens. I have no idea how he'll testify on that date. I did read through the deposition. It's up to them. Next thing that I had, I heard a lot about potential benefits with the U.S. Attorney's Office and potential benefits that might have been promised to him. From my understanding, and I just need clarification so that I'm on this right track, all of those time limitations have passed. He's served all his sentences. So
No, he's still under sentence and he is waiting. He's waiting to be released to a halfway house, but his maximum sentence expiration is in February of 2027.
okay,
And regardless, Judge, that's still relevant to the statement that he made in 2022.
well, it depends because he could get on the stand now and say, I only said it to get a benefit and I didn't get my benefit, so none of what I said is true. That's very simple for him to do. It's not what he said in his deposition, but he was hoping for certain benefits. And if his testimony is going to be consistent with it now, where he doesn't have any real benefit, I don't see how that would be relevant, but
And I
state,
think they're getting a little misconstrued here. There's what George Jones believed and that and hoped. And I think he said he only really had a brief contact with Michael Von Zam one time in person when he was there speaking to law enforcement officers, and Michael Von Zam came in the room briefly near the end. But did you say 5 minutes?
It was 20 minutes.
I would think that.
he was being, right, he was being questioned by the detectives, not by
And
Von
Michael
Zam.
Von Zam was present in the room, but he only had a brief exchange with
Right.
Michael Von Zam. And most of what he was saying was based on George Jones's communications with his own attorney about what he hoped to happen.
That was Mr. Cariglio.
And then maybe Michael Cohen.
Right.
And then, so he's had a number of attorneys, but those conversations were not directly with Michael Von Zam for the exception of that one brief exchange. And it was during interviews by law enforcement officers. And he came in the room for only a small portion of the time when he had been there. So I just want to make that clear because it's a little misconstrued here.
So what he testified to was about 20 minutes. When he spoke directly with Mr. Von Zam. He made it very clear that even if he wasn't speaking directly with Michael Von Zam, when he was speaking with his attorneys and when he was speaking with a sergeant who was a conduit between him and Michael Von Zam, he believed that those communications were being conveyed to Mr. Von Zam, and his attorneys told him about statements that Mr. Von Zam made to him. He was very clear about that.
All of these things, I think the underlying thing is what George Jones hoped to happen, what he thought would come of this, and what he was trying to read between what his attorneys told him, but then when directly asked, he couldn't come up with that. And it's clear from emails that were previously disclosed last July, as well as through a public records request the previous March,
that there were no promises made, that there were no contacts with the US Attorney's Office asking for any sort of sentence reduction. And as we sit here today, more than 4 years after he made that statement, nothing has been done in terms of that. And I think that was very clear. I mean, George Jones made it very clear that he's very disappointed and he didn't want to cooperate. And at one point, as reflected in those emails, he wanted to withdraw his statement, not because it wasn't truthful. And he's been very clear anytime he's been contacted that everything in his statement was truthful. However, he didn't wish to put himself at risk.
And so a few things on that. When the state says that everything he said was truthful, there was a moment in deposition where he pointed out that Detective Grossman and the state had been telling him, tell the truth, do the right thing. And then he said, yeah, that's an inside joke between us. I said, that's a joke? He said, yes, that's a joke. So I don't know how much stock the state wants to put into him saying that he's being truthful. And with respect to reading to whatever George Jones inferred, he testified that he was also told to read between the lines. And the operative question.
And wait, who told him to read between the lines?
Detective Gross.
Okay,
Can we just take a step backward here?
Yeah.
A motion to dismiss, and what they're talking about is possible things that should be addressed in a motion in limine regarding possible cross-examination.
well,
Not things that rise to.
I know, but she said there were 3 things in the motion to dismiss that she wanted to address. I said, we can still do number 1, and she start with number 2, and I'm going to address them for purposes looking at it for a motion to dismiss. I don't see, we haven't gotten, I stopped her to the point where she's going to correlate it to the motion to dismiss, only because I had so many questions along the way I needed answers to so that we could continue.
And do we have a copy of the transcript?
I do. George,
Official sworn.
I have not
copy of the
received the
transcript.
certified transcript. What I attached was a link to the audio and an unofficial transcript created therefrom, but we can play the audio.
right, I have,
So,
hold on, I have received,
objections, Bob.
yeah, hold on. It says what I received is Exhibit D of the motion. And it says deposition transcript of George French Jones. It doesn't say,
It should say that it is unofficial.
doesn't,
Yes.
maybe you could, it's what, it's labeled, Exhibit D is labeled that. I don't know if later. And then I have a
No, so
transcript.
In here, the deposition transcript from his testimony in the Keandre Fields case.
Okay, I'm reading what it says, right. That's a deposition transcript of George French Jones on the Keandre Fields case. That's what I have. That's what you provided me. That's what I
also
highlighted and read through,
provided Exhibit L.
right? That's in the new
Yes,
subset, right? Okay,
and that one is very clearly designated unofficial.
okay. I haven't gotten, I'm looking at the one that I read through and I highlighted, and it also has the hearing transcript excerpts from sworn testimony of ASA Michael Von Zompt. And I went through and highlighted that as well.
So, Your Honor, this morning I had a chance to go through defense counsel's motion and
Which motion?
the motion to dismiss.
Okay.
And realized that they attached a transcript there. So at this time, I'm filing state's motion for a protective order or order to seal the deposition transcript pursuant to Florida Rule Criminal Procedure 3.22 H1 here, Your Honor. And Florida Rule Civil Procedure 1.31084. So, Your Honor, the state never consented to an audio recording, and nor would we have in this case. George Jones is currently incarcerated, as we've discussed, in an inmate in federal custody. When he was first listed as a witness in this case, he was attacked in the Miami-Dade County Jail, and he is very, very concerned for his safety. Those were the emails that how he explained the substance of the emails he sent me last July. He was very upset that we would transport him for trial without reaching out and talking to him, and that he was concerned for his safety being housed in the Dade County Jail. He expressed those concerns again in April of this year, when he was going to have to be transported down for trial. And then when he got there, I met him, myself and ASA Rodriguez for the very first time, just prior to the deposition when he was brought to our office. And he said his biggest concern is for his safety as a witness because he is an incarcerated inmate. And I don't think his transcript should be something that is publicly available. When we read the defenses, I read the attachments, and I'm filing this morning because I saw that it was attached. And we, under the Florida Rules of Criminal Procedure, you have to notice the deposition, which the transcript, the notice is attached there. This is a very short motion. You have to notice both parties that you're seeking to record it. We were not noticed. It's not in the written notice. And we had previously in prior depositions, and the defense has used the same court reporting firm throughout, said that we asked what it was being recorded for, because as your honor is aware, we now do a lot of things on Zoom. And it's for the court reporter to generate their transcript. We do not consent, and it has been in 0 depo notices to that being audio recorded and released to either side or either party.
On the audio recording, it literally says the beginning starts with this deposition
Is
is
being-
being
correct.
audio recorded.
And I knew it was being recorded, but the court reporters usually use that to generate their transcript. And it has been asked before in prior depositions. I should have asked this time, but there've been like over 100 depositions in this case. And this is the first time I've become aware that there was an audio recording, and an audio recording that was not for the court reporter to generate the transcript, but that was provided to the defense. So I'm very concerned by this. I don't want this to be publicly disseminated. He's very concerned for his safety. So we want it to be sealed, and there had not been a copy yet requested for the court file. So at this time, I was unaware that there was something else existing. And we were going to ask that that be sealed so that his words were not publicly available. And it's something the court can consider in both parties, but not in the court file.
Okay, so it's just like standard when I had a stenographer here for all the years that I did, they would put a little microphone here and they would record it to help them type down everything, but not to provide those transcripts, not to provide the recording. So they would make their transcripts, and then that recording, as far as I'm aware, was destroyed, and it wouldn't be disseminated to anyone else.
Judge, and you can purchase the audio recording.
That
Only-
should not
right.
be happening, and
Right.
it has not been
Right.
noticed, and we had,
So there's actually a statute
yeah, it's cited.
that would be violated if in fact that were to happen without consent of both parties.
And that's governed by the Florida Rules of Civil Procedure, which
Right.
governs depositions. So, well, I was very concerned and very surprised when I saw that that was what was contained within defense counsel's motion.
So this, so that I understand, this unofficial transcript that you provided is not an unofficial transcript from the court reporter, it's an unofficial transcript from the defense attorneys?
Created from the audio.
Oh, boy. All right. So that's a big problem. Let me see the attorney sidebar. All right. Based on some of the issues that we've discussed at sidebar and what has arisen unexpectedly, I am going to stop the rest of the hearing on this motion until we resolve some of those issues. And we will reconvene on Wednesday just to hear whether or not that witness is going to be testifying on all of those motions, because I'll have to set those on a different day, or if it's going to become moot. And I anticipate from what we've discussed, there's going to be additional motions that the state's going to file, and we'll address those and set them when they come in. We're well in advance and everyone has time to prepare. All right, but I will ask the defense if they have had an opportunity to review the state's motion for the protective order and to seal the deposition transcripts and the links. I don't remember if you said you added that to here, Ms. Diamond.
Just at the end that there was no consent for either of these and that we would ask that those be sealed.
Okay, but you have both the link as well as the purported transcript?
I think I did audio and or video.
I don't know, let me see.
In the last, line
See.
motion. The transcript, audio, video.
Oh, the last thing I have is that you all didn't consent. To link.
Oh, did it just cut off? Because we were not aware of what, if the last thing should be aware for this request, this court issue a protective order, which seals the deposition transcript and any audio or video recordings that may exist.
Okay, defense, have you had a chance to read it? I'm reading it as we speak.
And we have no objection to sealing.
Give an order.
I will draft one right now.
Okay, and do you want to sign this so I can put it in the? Or you already gave him one? So this is my copy? Or copy,
Yes, Your Honor.
okay. Okay. Thank you all for your time, and we'll set this please on calendar for Wednesday. You can set it for, yes, for 10:30. Yep, thank you.
Perfect.